Question 116. Wayne owns a home in suburban Sacramento, with the boundary of his property bordered by the city street. A large palm tree at that end of Wayne's property has rotted and, during a particularly stormy day, falls onto the road, crashing into Norman's car as he drives by and seriously injuring him. If he sues Wayne for damages, Norman will likely A. Win, because Wayne should have removed the rotted tree from his property. B. Win, because Norman was seriously injured. C. Lose, because Wayne did not know the tree was rotted. D. Lose, because the storm causing the tree to fall was an act of God, not Wayne's fault. Correct answer is A. Win, because Wayne should have removed the rotted tree from his property. The general rule regarding duties owed to persons outside the owner's land is that the owner has no duty of care with respect to natural conditions, such as trees or rocks or other naturally existing objects. However, this general rule only applies to rural areas. Here, Wayne's land was in an urban setting, so he owed Norman a duty to keep him safe from naturally existing conditions on his land. Wayne has a legal responsibility to maintain his property in a reasonably safe condition. Even though the tree fell due to a storm, the fact that it was already rotted is key. A property owner can be held liable for damages caused by a hazardous condition on their property if they knew or should have known about the hazard and failed to take reasonable steps to correct it. A rotted tree is a hazard that a reasonable homeowner should be aware of and address. The storm might have been the immediate trigger for the tree falling, but Wayne's negligence in maintaining the tree is the more direct cause of the damage to Norman. The act of God defense is unlikely to succeed if the hazard, the rotted tree, pre-existed the storm. Question 117. The area between the bottom of the floor joists and the ground is called the BTL. A. Joist to ground ratio. B. Crawl space. C. Under the floor dimensions. D. None of the above. Correct answer is B. Crawl space. The space between the bottom of the floor joists, the structural members that support the floor, and the ground is called a crawl space. It's a shallow, unfinished space beneath the lowest floor of a building. Crawl spaces are common in homes with raised foundations and serve several purposes. Access. They provide access to plumbing, electrical wiring, and other utilities located beneath the floor. Ventilation. They can allow for ventilation under the floor, which helps prevent moisture buildup and potential structural problems. Foundation support. They can provide support for the foundation and help distribute the weight of the building. According to the FHA, the minimum amount of crawl space must be 18 inches. Question 118. A property is sold at a foreclosure proceeding for $200,000, but the property owner owes a total of $250,000 to the lender on the mortgage. The difference of $50,000 is called A. Loan workout. B. Deed in lieu of foreclosure. C. Short sale. D. Deficiency judgment. Correct answer is D. Deficiency judgment. Foreclosure. When a borrower fails to make mortgage payments, the lender can foreclose on the property. This means they can seize the property and sell it to recoup the outstanding loan balance. Sale price versus loan balance. In this case, the foreclosure sale only generated $200,000, while the borrower still owed $250,000. This leaves a $50,000 shortfall. Deficiency judgment. A deficiency judgment is a court order that the lender can obtain against the borrower for the remaining balance owed after a foreclosure sale if the sale proceeds are insufficient to cover the debt. It allows the lender to pursue other assets or income of the borrower to satisfy the debt. Question 119. A statement by a real estate agent such as, "There is no better house on the market in this price range than this one," would likely be considered an example of A. Puffing. B. Opinion. C. Misrepresentation. D. Deception. Correct answer is A. Puffing. Puffing is exaggerated or boastful statements about a property's features or benefits that a reasonable person would not take as a literal representation of fact. It's considered harmless exaggeration and is generally not considered misrepresentation. Saying, "There is no better house on the market," is a classic example of puffing. It's subjective opinion, not a verifiable fact. In order to prove false advertising, it must be shown that the statement or representation was deceptive. False advertisement is motivated by a desire to deceive or mislead the public. On the other hand, puffery is usually a matter of opinion rather than a factual representation. Question 120. Which of the following is an implied covenant in a lease? A. Property description. B. Renewal terms. C. Quiet enjoyment. D. Security deposit. Correct answer is C, quiet enjoyment. Quiet enjoyment is an implied covenant in most leases. It guarantees the tenant's right to possess and use the property without interference from the landlord or anyone claiming through the landlord. It doesn't have to be explicitly written in the lease. It's implied by law in most jurisdictions. The other options are typically express covenants, meaning they must be specifically stated in the lease to be enforced. Question 121. Which of the following kinds of contracts must be in writing to comply with the statute of frauds? A. A contract that is to be performed within 1 year. B. A year-long lease. C. A sale of crops. D. A contract that covers a 2-year period. Correct answer is D. A contract that covers a 2-year period. The statute of frauds requires certain contracts to be in writing to be enforceable. A key category is contracts that cannot be performed within 1 year from the date they are made. Since a contract covering a 2-year period, by definition cannot be completed within 1 year, it falls under the statute of frauds and must be in writing. Question 122. Broker Andy represents both seller and buyer in a real estate transaction. Although Andy disclosed this dual agency in a written disclosure form provided to both parties before the sale closed, he did not mention anywhere in the form that the seller was an old college friend. In this situation, Andy is A. Not liable for any wrongful behavior because he notified the parties in writing regarding the dual agency. B. Liable for disciplinary action from the real estate commissioner. C. Not liable if both parties consented in writing to the dual agency. D. Either A or C. Correct answer is B. Liable for disciplinary action from the real estate commissioner. While disclosing dual agency is essential, it's not the only disclosure required. A broker must also disclose any other material facts that might influence the parties' decisions, including any relationship with either the buyer or seller. The fact that the seller was an old college friend is a material fact that should have been disclosed, as it could potentially create a conflict of interest. Failing to disclose this relationship, even with written dual agency consent, is a violation of the broker's fiduciary duties and could lead to disciplinary action. Question 123. A broker from another state refers a buyer to a California broker who procures the sale. According to the real estate law regarding commission splits, the California broker A. Cannot split a commission with an out-of-state broker. B. Can split a commission with an out-of-state broker. C. Can split a commission with an out-of-state broker if the property sells for over $1 million. D. Can split a commission with an out-of-state broker if the California broker has been licensed for over 10 years. Correct answer is B. Can split a commission with an out-of-state broker. California real estate law allows a California broker to share commissions with a broker from another state, as long as the out-of-state broker did not perform any acts in California that would require a California real estate license. The referral is considered a legitimate service, and the commission split is permissible. Question 124. Similar to a trust agreement that secures a loan on real property, A.T. secures a loan on personal property. A. Pledge agreement. B. Security agreement. C. Collateral promise. D. Chattel holder. Correct answer is B. Security agreement. A trust agreement secures a loan on real property. A security agreement performs the same function for personal property, chattel. It creates a security interest in the personal property, allowing the lender to repossess and sell it if the borrower defaults. Question 125. Assignment is when A. One party is completely replaced by another. B. One party transfers its rights and obligations under the contract to another party, but remains secondarily liable. C. A contract is terminated but previous contractual acts are unaffected. D. A contract is terminated and any consideration given is returned. Correct answer is B. One party transfers its rights and obligations under the contract to another party, but remains secondarily liable. In an assignment, one party, the assigner, transfers their rights and duties under a contract to a third party, the assignee. However, the assigner remains secondarily liable if the assignee fails